Supreme Court of India has called for the application and extension of the quote-unquote creamy layer idea in reservations for the scheduled castes and scheduled tribes and exclude castes from the benefit of reservations. In a significant ruling, a 7-judge bench of the Supreme Court of India by a 6:1 majority has held that subclassification of scheduled castes and scheduled tribes is permissible to grant separate quotas for more backwards within the SC ST categories. However, 4 of the 7 judges added that the state must evolve policy for identifying that creamy layer so as to exclude them from the benefits of affirmative action. A bench of 7 judges comprising were called on to decide the legality of the law enacted by the Punjab state government, which had given preferential treatment to Balmikis and Mazhabi Sikhs within the SC reservation. While the idea of subclassification has been supported by 6 of the 7 judges, Justice Bela Trivedi delivered her dissenting verdict on the issue, holding that subclassification as envisaged in the Indira Sawhney case for OBC reservation was not permissible. That's the big story that we're tracking at this hour. To understand it better, I have my colleague and friend Ashok Bagaria joining us here in the studio. Ashok, thank you so much for taking time out to be with us over here. In a sense, simplify this latest Supreme Court ruling for us. A 6:1 ruling is fairly emphatic from the Supreme Court of India, isn't it?
Yeah, so basically there are 2 aspects of this particular judgment which has been rendered by the Supreme Court of India today. The first deals with the core legal aspect, whether subclassification within scheduled caste and scheduled tribes category was permissible for extending the benefits of reservations in jobs as well as admission to government colleges were concerned. On this aspect, the Supreme Court has, by a 6:1 majority, held that subclassification was permissible because here the subclassification idea promotes equality and passes on the benefit of reservation to the weakest amongst the weaker sections of the society. Now, the second important aspect has been dealt by 4 judges, whereas the 3 other judges have been silent on this aspect. The 4 judges who dealt with this aspect said that, look, we agree that subclassification of castes within scheduled caste and scheduled tribes for the purposes of giving preferential treatment was permissible, but at the same time, we believe that this idea of subclassification, which was first introduced by the Supreme Court bench of 9 judges in the Indira Sawhney case, should apply in its totality to the scheduled caste and scheduled tribes also. So, in the Indira Sawhney case, what the 9 judges of the Supreme Court had done was that they had said that subclassification of castes within the OBCs was permissible, and also that if there was a quantifiable and empirical data with the states, they could also exclude certain castes within the OBCs because they had adequately benefited from the benefits of reservation. So, they say that this whole concept of creamy layer should also apply to the scheduled caste and scheduled tribes. Now, this is significant in the sense that a combination of 4 judges have for the first time in a single voice said that, look, the state governments or the state must strive to implement this idea of creamy layer for scheduled caste and scheduled tribe reservation also. The benefit of such an idea of creamy layer would be that it will gradually start excluding the castes which had already benefited from reservations, but will also ensure that the weakest among the weaker sections will get the benefits of reservation.
Okay, now you have a verdict, Ashok, where 6 out of 7 judges have held a majority. They've held that subclassification of SCs STs is permissible to grant separate quotas for the backwards in those categories. But 4 of the 7 judges have said that the state must evolve policy for identifying this creamy layer so as to exclude them from the benefit of affirmative action. In that sense, that is also now putting the onus back on the state.
Yes, the onus is definitely on the state. And
by state, we mean the country.
The country, that is the central government or the state governments. But here, what we have to understand is that this is obiter dicta of the judgment, in the sense that the court, the 7 judges, were not actually called on to decide on whether the aspect of creamy layer would be applicable to the scheduled caste and scheduled tribes only. These are passing remarks by the judges during the course of their judgment. This does not carry the weight of a direction or an order passed by the Supreme Court of India. However, what is significant is the fact that there are judges in the Supreme Court who believe that this idea of reservations for SCs, STs must go to the people they are originally meant to, and at the same time also start excluding people, those who have already reaped the benefits of reservation. In fact, one judge, Justice Pankaj Mittal, in his separate opinion has written that as far as the SC ST reservations are concerned, they should only be given to one generation, because after you have received the benefits of reservations, the second generation really does not need it. So there has to be some kind of equity which has to be evolved, so that even the weakest of the scheduled caste and scheduled tribes reap the benefit of reservations. Because today the situations on the ground is that there are only some castes and communities who have access to the benefits of the reservations, and when they have access to the benefit of these reservations, what really happens is that the people to whom it was actually meant to trickle down to continue to be denied the reservation, the benefits of reservation. So the court is saying that the way forward is that you have to apply the policy of creamy layer for providing or in reservations for the scheduled caste and scheduled tribes also.